Hi guys, this is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly call for the community, just answering the questions. So beginning with the first question, which is actually a more or less a frequently asked question. Let's begin with WeCom001's question. Works for a consulting company, A, and he's got his approved I-140 in EB2 with priority date of March 2012. Client company B is offering full-time job planning to transfer. So A's got the I-140 approval and wants to join B. B is a big financial organization. So can I keep my perm I-140 active with the current employer? And the answer is yes, you can, as long as you have the good faith intention to join back company A and company A has the good faith intention to hire you back. Okay. One thing there, I have mentioned this before, I'll do it again. It's very important to understand that USCIS could ask you this question, and they've done that once in the last 30 years that I've been in practice. They've now not, I've seen these kind of situations many, many times where you change employers and the old employer is keeping your green card active. In that particular case, they actually asked our client, why did you jump ship? Why did you go from one employer to another? And we actually had a very good explanation in that case. The old company was a house of JD Edwards, which is an ERP package, as many of you might know. And our individual client wanted to get more experience in the more happening and the more popular ERP packages, such as PeopleSoft, um, Oracle applications, and SAP. So that's why he changed for a couple of years and then he came back. So they can take that position. Although, like I said, they've not done that in so many cases we have seen. They could say, if you wanted to keep working with employer A, why did you change jobs? Just keep it in the back of your mind. That is a question that can be raised, although I've never seen them do it. So to answer your question, can company A still keep my green card active? The answer is yes. Will there be any complications on the company or on you I just mentioned? As long as the company has the ability to pay wages for all the employees that they are filing for, including you, there shouldn't be any problem. And company A lawyer is telling you that this may raise complications and bad influences. I would like to know how. See, I understand people have reservations, but it's always a good idea to say, give me an example. What does this mean? What kind of complications? Other than the ability to pay wages and the um, explanation that could be asked from both the employer and employee, why, Mr. Employer, are you letting him go and keeping him on and at the same time, and why, Mr. Employee, you are leaving? As long as you have a good explanation for that, keep it truthful, don't make things up. I don't see any problem. Okay. Then you asked me, number two, if company A I-140 is active and I work for company B and the priority date becomes current, should I come back? And the answer is no. Actually, um, Bill Yates, in the Yates Memorandum of May 2005, um, dealt with this situation. He actually said, so if there's a future employer and you have actually not yet joined them, but then the priority date becomes current and you file a 485, after 180 days, you actually never have to join them. You can use AC-21 and port over to either the current job you're doing or another job without ever joining the employer who actually sponsored you. That's perfectly legal. Number three, will my H-1B extend beyond 6 years with company B? The answer is yes. Yes. Because there is no requirement that the employer who holds the I-140 and the employer who gets the benefit of the H-1 extension have to be the same. They can be different employers. Um, what I'm going to do is, Vikram, there is actually another related question, I think, to this one. So let me scroll back and then usually I don't do questions till the end, but because I'm going to present this as a frequently asked questions for other people in the community, I think I'm going to ask you guys to raise any questions you have concerning these issues that I've discussed. So let me just pull out the second question in the same series, kind of the same idea. One was AC21 from Srinivas. I don't think that is the question. Then there's a lottery issue. I think this is the one. So this is from Rahul. Question number 7 is kind of related to what we discussed. Working for an employer A and its direct client B. Employer has full control as my supervisor. As my supervisor at client B is also an employee of employer A. I-140 is approved, priority date is not current. So 3-year extension beyond 6 years is already done. So questions are, if I want to change my job to B, here also going from consulting employer to the end client, I want to change over. Can I transfer this H-1B on the basis of the I-140 approval from employer A? The answer is yes. Caveat is only this: if the I-140 by employer is revoked, you will still carry your priority date, but you will not be able to get further H-1 extensions. So you will have that much time to file another green card. Does the new employer have to file a new perm and new I-140 subsequently? Yes, but they'll carry the same priority date even if the old employer has revoked the I-140. 3, should this new perm with employer B be filed before or at the time of filing for H-1B transfer? Early as possible. It doesn't have to be right away, because typically you'll have about 3 years and you want to file your labor cert, of course, as early as possible, but definitely before the 3rd year or the last year of your H-1 begins. I've heard that you can carry your priority date. The answer is yes, it is automatic. There are no other forms. Any possible risks? I can't see anything, really, Rahul. So, okay. So question number 1, which was Vikram and Rahul. Guys, do you guys have any follow-up questions? If you do, or anybody who's in the call has questions related to what I discussed, press *5. Press *5 on your phone. I'll take those questions first. *5. Any questions following on what I discussed? One question, 2 questions. 2 people have raised their hands. Okay, let's just deal with these first and then we'll go on to the rest of the questions. I'm going in the order in which you called into the conference. Woodbridge, New Jersey. Go ahead, please. Woodbridge, New Jersey. Woodbridge, New Jersey. Go ahead.
Yeah, hi Rajiv. So the question I had was, actually you were explaining when you move from employer A to employer B and you don't have to work for employer A at all. Can you explain that a little bit more?
Yes.
How in what scenario we don't have to work for employer A?
Yeah, let's look at what AC21 requires, because that's an AC21 issue. What AC21 says is this: as long as you have a same or similar job and your I-140 and 485 has been approved, 485 pending 180 days, you can work with any employer who gives you a same or similar job. Now, keeping that principle in mind, your green card is being processed either by your current employer or by a future employer. In either case, when you get your AC21 eligibility, that is 485 has been pending 180 days, so you've joined employer C or B, whatever you want to call them. Your green card is in the hands of the old employer or a future employer whom you have never joined, but they're processing the green card. You are working for another employer, employer B, call C. Okay, so employer C is the one you're working for. When the AC21 eligibility period is over, 180 days, 485 pending, you actually don't even have to join the old employer or the future employer as long as the job that you're currently doing is same or similar. Does that make sense?
Right. So it's only applicable if the more than 181 days pending. If the green card comes before 180 days, then I have to join employer A back.
You know, I have dealt with those situations before. I would advise if it is possible to do so. But if you don't do it, I think there is some ground for us to be able to defend it. Although I personally think it's a good idea to join them at that time. So if it is approved before 180 days, before AC-21 eligibility is attached, I would probably want you to join that employer. Yes.
Is there have any impact on the further like citizenship, naturalization, how much time you work with employer A, the future employer, or current employer? Does that have any impact on?
Most important thing is that when you take the job with the sponsoring employer or any green card employer, you take it on a permanent basis. Permanent does not mean forever. Permanent means when I join the employer, it is my intention to stay with them for an indefinite period of time. So let's say you are working with one employer and the green card gets approved, you move over to the sponsoring employer, but you don't resign from the present employer, you actually just take a leave of absence. It's quite obvious that that's not permanent. Okay, so if you actually resign, change, move cities, change your driver's license, get an apartment, that is obviously a permanent job. Or once you join them, even after a few weeks, if you want to switch, as long as you took the job on a permanent basis in your own mind, you change your mind after a few weeks, that's fine.
Okay.
Okay?
Thank you.
You're welcome. And the second question in the same series is from Kentucky. Go ahead, please, sir, or ma'am.
Yeah, this is, I'm calling from Texas. This is regarding the future situation where I'm like in case we get a law saying that the H4 dependent can get a work permit provided I-140 is approved. So situation is like I work for a company A and I-140 is approved, and now I get the work permit for my dependent, that is the EAD card, and then I move to the company B. And will that H4 dependent will be still able to work using that EAD based on the previous employer's I-140?
The way the regulations, the proposed regulations are currently written, the answer is yes. Okay.
Okay, thank you.
Unless USCIS goes back and changes something, remember the regulation is still under notice and comment till July. In July, they will collect all the comments. Let me finish. They'll collect all the comments and then they will finalize the regulations. Regulations are likely to stay pretty much the same. Okay, so yeah, you'll be all right.
Yeah, and just another leading question that like, what if the new employer, like meantime, the new employer again starts with the green card process, filing the perm and then I-140, but this should not have any implication, right? The previous EAD card, which is valid for maybe 2 years, there should not be any issues, right?
And the answer is I don't think so. I don't think it should have any problem.
Okay. Thank you, sir.
You're welcome.
Okay, thank you, sir. Yeah.
Sure. All right, guys, I want to remind you, we are not dealing with all questions, just what I had discussed, changing employers, I-140 approved, issues that I discussed earlier. There's one more hand from Pennsylvania. I hope this is a related question. We're not dealing with new questions. I'll come to that in a little bit. Pennsylvania, go ahead, please.
Yes, sir. I'm actually a Canadian citizen, and I'm right now staying in Pennsylvania on TD status. Okay. And I would like to invest like 100,000.
Okay, that has nothing. I'm sorry. That has nothing to do with what we discussed. So you're gonna have to wait until I come to the end of our discussion. Please hold on. Okay. I'm just dealing with derivative questions, not new.
Oh.
I'll get to new questions at the end of the call. So, okay, so we have discussed the I-140 issues. Because this was a frequently asked area, I wanted to cover this first. Now we come to question number 3 from GC India 123, who says, I've received my notice of intent to revoke. They have sent it to us. I guess I must have already discussed that. If you sent us the document, I'm sorry, I don't remember what happened with your case, but you sent it back to us sent it to us in June, on June 5th or somewhere there. I would have talked to you already. So the question is, when I have an NOIR, can my wife start a new green card process with any employer, A or B, current or future, even though she's not got an H-1B? The answer is yes. A green card can be started even while you're on H4 or L2 or in a non-work status. F1, F2, J1, J2, maybe not, but HL, it's rather easy. What happens to her green card process if my green card is denied in 1 month? Her green card process can go on. It has nothing to do with your denial. On what status is she after my green card is denied? She has no status. Just because your green card is pending does not give you status until you come to the 485 stage. So she'll probably have to leave USA unless she's on H1 or some other status. Can she continue green card process with employer even after green card is denied? And the answer is yes. But she can't stay in the United States. For that, she needs her separate status. Okay. Then we come to the next question. YS Vas, who's Srinivas, he says, I'm working for company A for 8 years. They filed my GC in EB2 category. I've got an EAD. I want to take a full-time opportunity with company B with different skill set from quality assurance to SAP. That has nothing to do with my current job. Can I change jobs from company A to company B with different job description during I-485? Well, you can, because you've got your EAD, but you must start a new green card. Okay. Assuming company B will provide new job description related to SAP that will not match with company A job description. What happens if I don't file AC21? See, I don't think you could qualify for AC21. It looks like you are going from quality assurance to something completely different. It's a little difficult for me to say that this will be an easy AC21, although nobody really knows what same or similar means in the context of an AC21. What I would recommend is you can join them, but start a green card with the new company, and if possible, also get an H1 processed. Okay, that way you're covered from every angle. Kishore, number 5 question. I got my H1B approved a couple of months back. Passport number was incorrect. I've already answered this question actually. I told him just because the passport number is incorrect on your H1 does not mean you cannot transfer it over. Okay. Then Joydeep Ghosh, question number 7. Filed H1B, got selected in lottery. He's got an RFE. They're questioning specialty occupation in the field of chemical engineering. And you are working as a program manager in the IT industry. Could you please let me know what sort of documents would help me get through this RFE? No, Jaideep, I cannot. The problem here is that this question has so many possible answers, and each one would depend upon your specific case. My advice to you is go get yourself a lawyer. Okay. There are, if I remember correctly, and I try to remember off the top of my head, there are 4 ways you can prove that a job requires a bachelor's degree specifically in one field. And one of them is that the employer requires it, has always required it. Second is it's the industry standard. Third is the job is so complex that nobody without a degree can do it. There are all these. So you have to choose which categories you're going to prove your case under, and then proceed accordingly. So I cannot really answer your question in the abstract. Get yourself a lawyer. I would strongly recommend it. I see there's a raised hand. I'm not sure what that is about. I want you to remember I'm not answering any new questions. So, but go ahead, Arlington, Texas. You have a question?
Hey Rajiv, I think I raised my hand for the previous question on AC21.
Hang on
If
one
it's still a
second.
good time, I would like.
Hold that thought. I'm going to come to that. Once I finish all my questions, I will ask people who have posted to raise their hands. You can leave your hand raised. I'll get to you. Just, okay. So next question is from Rahul. That I already answered because Rahul's question with Vikram's question I already combined and answered. Then we come to question number 9, which is drop PU666. I entered USA through my parents under F43 visa. I'm not sure what that is. At the age of 21. I'm 27 now. Oh, selective services. You forgot to register for selective services. Well, once you're past 26, I think you can't register for selective services. But if during the naturalization this becomes an issue, you'll probably have to provide an affidavit and some proof, etc., that your failure to register was not willful. In other words, you didn't do it on purpose, it was just a mistake. Okay, so they will not register you for selective services now, but they will probably ask you to explain why you did not. And that's usually not such a big deal. It's a common problem. So next question is from Tom16, who wants to know about his wife's F1 stamping in Canada. She came on F2, converted to H4, went to India, H1, H4 stamping, then converted her back to F1, change of status, I believe. Now she's got F1 change of status. So in the meantime, they got Canadian permanent residence. They need to go to Canada to complete their landing. Can she use automatic visa revalidation? The answer is yes. AVR is available because she changed status within the United States. Her trip is going to be less than 30 days, and she's not going to apply for a visa while she's in Canada. So I don't see any problem using AVR for this. Any adverse effect of AVR? I don't think so. On your green card process, I don't think so. On your visa process, I don't think so. If we do need to go for visa stamping, it's not really relevant here because you're going to go for AVR. Sanchalanam wants to know, I'm in USA on H1B since 2003, working with my current employer on H1B for the past 8 years. I-140 stage completed. Now there are going to be major layoffs. As I am in this country for more than 10 years, it is my understanding that currently my H1B extension is possible only due to my green card application. That is correct. Can I still move to another company? Yes, what you should do is immediately apply for your H1B transfer and do it premium processing so that before the company lays you off and revokes your I-140, you've got your H1B. Okay. Yeah, do it as quickly as possible. What alternatives do you have? Well, you could always go on H4 because your spouse is also on H1B. So H4 is no problem. But if you want to continue working, then H1B is the way to go. Do you need a paid consultation? These issues appear to be generic. I don't see any need for a paid consultation, Sanchi. And if you are here and you have any follow-up questions, I'll be happy to answer them. Let me just finish the first round of questions, then we can talk some more. So Abhi wants to know, Kumar_Rashmi wants to know, mother-in-law had filed I-130 for her sister. Mother-in-law passed. What can be done for the I-130? Well, she has no blood relatives in USA except niece and nephew. Look into two things. One is a Section 204 survivor benefit, But that is not applicable, I think, here, because for that, the alien relative must be living in the United States. And the second is called humanitarian reinstatement. I don't think you have any grounds for humanitarian reinstatement. So in my view, there's not much you're going to be able to do, but follow the Section 204 survival benefits and also humanitarian reinstatement. Maybe you'll find something. I haven't researched this issue, but I think it's a very slim chance that you can do anything about this. Sripal, who's Sripal K, wants to know, wife has worked for company A for 5 years on H1, I-140 approved, green card filed in EB2 from company A. Company A has terminated the business, so she has moved to a different firm, company B. She got her H1 approved from company B. So whether she has to start the green card process again? Yes, she does, all the way from the very beginning. When? As quickly as possible. What are the current timelines for getting labor approved? The timelines are on our website. They're also on many websites. Depends upon a number of variables. If you are lucky, maybe 6 to 9 months. If you get stuck in audits and supervised recruitment, it could take a lot longer. Rakesh VVV wants to know, working on H1B for a client through employer A. Company has not started my green card. So while working for employer A, I want to know if there's any option for another employer. Yes, of course, we've been talking about that. You can get your green card filed through another employer as long as you have the good faith intention to join them and they the good faith intention to hire you. Fact of the matter is, there comes a point at AC21 where you don't really have to join them, but the intention should be there when you start. If I get to I-140 approval from employer B without working for employer B, can I use the priority date for another employer? Yes, absolutely. So your green card was started by B, and then company C wants to start another green card and use the I-140 priority date of the old employer. The answer is yes, you can use it. Yes, absolutely. No problem at all. Negative consequences, just the requirement that you should have good faith intention to join. Naveen Chakoti wants to know, priority date is June 2008 EB2. 485 applied in Jan 2012, currently on EAD. USCIS has been issuing mass RFEs. Oh yeah, we are dealing with them, we know. I haven't gotten my RFE yet. So I'm concerned why I haven't received RFE. I don't think we've gotten RFEs in 100% of the cases. Let me double check that. Give me 1 second. Sumanji? Sumanji? Is anybody from AOS section, Prernaji, Bhartiji, anybody there? Yeah, just tell them to call me on my extension. I don't think we are getting RFEs in every case. They are coming in most cases. So no, I just want them to call me. I have a question for either one of them. Conference call? Just my telephone. So I don't think that's something to worry about, but if you are concerned, you can go ahead and pick up the phone and call USCIS. Bhartiji, who is this on the phone? Oh, Prernaji. Are we getting RFEs about the employment in every case, 485 case, or just some cases? Almost every. When you say almost, there are still some that are not. Okay, thank you. So it's not 100%. I just confirmed that. I think you should be okay, but double check. Contact USCIS, make sure everything is. They should be able to tell you. I hope they haven't lost the case. And that happens too. So then from Sai Sandeep, STEM OPT ends on October 30th, 2014. Not selected in lottery. Joined university for second master's, fall 2014. Visa stamp is good till 2015 December. Planning to travel to India in July for 1 week. Is there any risk? Yeah, there is a risk because you are basically starting a second co-equal degree. When you enter USA again, CBP can question that. I can't say that this will be a very uneventful entry. They can always question how come you started a second degree at the same level as you did the first one. Okay. Um, Cruz Pats wants to know, filing I-130 for mother. Father passed away 10 years ago. Do I still have to mention their name? Look, I can't help you fill a form, but as a general matter, whatever information USCIS asks for, even if the relationship was 10 years old or 20 years old, you should mention the name. Okay. MKB3, working on H-1B, I-140 approved, few questions regarding my options to stay in USA with my mother. Okay, your mother is here on a tourist visa. Okay, she has a tourist visa. What we have done is, you can't add her to your 485. You can't get her a green card. But we've done cases where we were able to extend her tourist visa almost many years because she has nobody to take care of her in India. And you know, we've been able to do that. We explained to USCIS, of course, it's not guaranteed to work in every case, but we've done this more than once. So you might be able to get her extension as long as she does not enter USA with the extension to stay indefinitely. If she enters and you decide to keep her there a few months later, you can keep trying to keep her here through extensions. You cannot sponsor your parents while you have a green card. Any other way we can live together in the US? Unless she has money to invest, EB5, investor visa, I think you can try just keeping her extensions on. The problem here is this. One thing that I would be concerned about is that if the extension is denied, then the next entry into the US would have to wait at least a year or so. So that's the risk we have to take. Do I need to live 5 years continuously to get citizenship? No, you do not. But the law is, out of 5 years, immediately before filing the application for naturalization, you must have been physically present in USA for 2.5 years. None of your visits to outside India should be 1 year or more. Outside USA should be 1 year or more. And if it's more than 6 months, less than 1 year, you have to explain why you were gone that long. Okay. Look into two forms. Look into the form I-131 instructions for re-entry permit and look into N-470. If you work for an American company outside USA, you might be able to preserve some of your rights under naturalization. Review those two forms. If you want to do a one-on-one consultation, feel free to do that. Otherwise, just call back in the next conference call in 2 weeks, and we can go over any specific questions you have on this. And by the way, I have a bunch of videos on how to maintain your green card, and just because you keep coming back every 6 months does not maintain your green card. You can still lose it. Your permanent home must be in USA, except if you qualify for N-470 and I-131. Soman Shah says, my green card was filed in EB2 category by my employer in Feb 2013. I've exhausted my H-1B years and currently on H-1 extension. Labor approved August 2013. I-140 filed September. Got denied, then filed again, then got denied. So it was denied like twice and filed a third time. But he keeps getting extensions based upon that. So they're also planning to appeal this. My concern is if I have to travel to India in first week of July, is it advisable? No, no. The problem is, even for people who have everything all clean in their history, no problems at all, getting H-1 visa stamping is so unpredictable. I would avoid it. Attorneys filing for an appeal, visa stamping is difficult. Now, if you are working in-house, your chances are better. End client, chances are worse. So I don't know. It depends. There are too many variables here for me to give you a good comment. If I-140 is denied, travel to India with it, can I get any other type of visa, like tourist, B, fresh? Fresh H-1L1 is not a problem, but if you have exhibited immigrant intent by filing Form I-140, you may not be able to procure visas like B visa, F visa, tourist visas, etc. easily. Is it possible or advisable to travel to Canada to get H-1B stamping? I think so. If you have no choice, I think Canada may be a better option. Can I immediately start my fresh green card process in any other category, say EB3? That's something your lawyer has to assess. I personally don't think there is any problem filing in the same category now because the I-140 has been denied. Department of Labor is not going to raise an objection to a new filing. Is there any other possibility for visa stamping? No. Mohit wants to know, I didn't read page 2 of these questions. 3 more messages. Okay, so these questions somehow I did not read. So let's just read it quickly. Planning to move back to India end of July. Current employer has office in India, offered me a position. Now the visa bulletin has said the dates are current. So I'm reconsidering my decision. These are my options as I know them. File 485, stay until I receive green card, then apply 131 for re-entry. That's one option. Can I travel to India after filing 485? You can, but it's not a good idea. It casts doubt about whether or not you intend to take the position on a permanent basis. How long to get approval of 485? Depends. Too many variables. Government tries to make all adjudications within 6 months, but that doesn't work always. There are people with 485s pending for more than a year. Do I need to work with current employer any minimum duration before I can file re-entry permit? I would say as long as you can. The most important thing is that you should have an indefinite intention to remain when you get the green card. And I discussed this about a half hour ago. I had a very lengthy discussion on that. Do I need to work with current employer? Okay. File a 184 to convert the case to, you can convert the case to consular processing. And when the priority date becomes current, they will interview you. I don't know what 184 is. I think you're talking about, I forgot the name of the form. Is it 824? The form that is action on an approved petition. I think that's what you're referring to. You have to check the current times. I don't know how long it takes. Does the priority date in CP follow the same dates order as 485? Yes, of course. How long does it take, and are there better chances to get approval from consular processing? No, consular processing can be more difficult because they could ask you questions whether you really have the intention to work here permanently. Is there any duration limit in which I must file my immigrant visa petition after I get notification from NVC? I think it's 1 year. NVC expects you to act within 1 year. Okay. So these last 3 questions I didn't see. They were on page 2. There's a question about a contract from D. Patel. I can't comment about the contracts. Contract laws are a matter of state. Every state has its own contract law. I cannot comment on contract law of any state other than Virginia and DC where I'm admitted. Federal law, we can practice for clients from any state. But if we try to practice state law, that's unethical. I can't comment. PRPLGRL, I guess Purple Girl. Sister had lived in USA for 13 years through undergrad and employment. When she decided to return to India permanently in May 2012. At that time, her green card application was being processed. She's got it in denial. She would like to come and visit. Is she eligible to apply for a visitor's visa? Of course she is. What are her chances? That's difficult to predict, especially because she applied for a green card. Worth a try? The fact that she was here and she left is a plus point. The fact she applied for a green card is a negative point. The fact that she stayed here for 13 years may be a negative point, but I think it's worth trying at least. Would she be eligible to apply for a student visa? Same chances as a tourist visa, in my opinion. Okay. Then the last question, posted question, is from, I guess, Rajashekar, K01, who wants to know, I'm a green card holder, got it 1.5 years back, applying for re-entry permit, multinational manager, consular processing. I've stayed in USA for about 12 plus months with 2 trips in between. Old parents in India, I would like to apply for re-entry permit. Post re-entry permit, in case I got married in India, so these are the questions. If I apply for re-entry permit and then I get married in India during this 2-year period, can my spouse come to work on work visa or student visa? Not student visa. That's difficult because if you have a spouse who's a US green card holder, they may not give them the student visa, but you can try. But H1L1, no problem. If spouse already had student work visa, see, H visas have no problem, but student visa before marriage can still be questioned. Post re-entry permit, in case I need to make short trips to USA, will this keep my current re-entry permit valid? See, re-entry permit allows you the option to stay away from USA for up to 2 years or whatever number of years government gave you. And it's a multiple entry document usually. So you can come as many times to USA as you like. Can the F2A be applied while I'm in India on my re-entry permit? I don't see any problem with that. I don't see any problem with that. Okay, so we are done with the questions that were posted. I'm going to begin first with follow-up questions, only follow-up questions. So people who have posted questions and they have any follow-up questions, please press *5. Others, not yet. We'll do new questions after this. So follow-up questions, press *5. 1, 2, 3 people. Okay, let's go in the order in which people join. One person put their hand down, put it up again. Okay, let's start in the order in which you logged in. Oh, four people. New Jersey, go ahead, please. New Jersey.
Yeah, hi Rajiv. This is in regard to last question on the page 1 about green card dilemma going to India permit try to get current. So you mentioned that it's not advisable to travel while 485 is under processing. I just want the clarification that I cannot even travel to India for short visit, or you mean that I should not move back to India?
Don't move back. Short visits are okay because the problem is, Mohiji, that you are indicating to the government that you want to take this job on a permanent basis. Okay, then you leave this job and you go to India for long term. I think that is questionable. We had this come up recently, a couple of months back. But there, the situation was that the employee had gone to India to set up a plant. They are manufacturers. He had gone to India to set up a plant for the company. So he was going to stay there for many months. So that was no problem. But if you don't have a reason, on the one hand, you're saying, I'm going to take this job on a permanent basis. On the other, after filing 485, you're moving to India. USCIS may not question it, but it's certainly something that leaves me a little uncomfortable. But short visits, short visits like a month vacation is no problem.
Okay. And if during the short visit, if my 485 gets approved, will I have problem entering back because now I have a different status, or I can enter back on H1 at that time?
No, people enter back on their re-entry permit, on their advance parole or H1 visa. Government lets you enter. There's no law on this issue, but I've had many clients enter on advance parole. Never a problem.
Okay. But right. Advance parole, so I should wait before advance parole come back.
You should.
I should.
That's probably
I should travel for short visit also before advance parole come back.
I would say that's probably a good idea. Yes.
Okay.
All right. Okay. Let's go on to the next raised hand. And then we'll start with the new questions. Arlington, Texas, go ahead, please. Arlington, Texas, go ahead.
Well, hey, Rajay, thanks for taking the call.
Sure.
So my question is related to AC21, okay. The portability. So my priority date is July 2009. So I'm in process of changing my job to a different employer, and they're currently processing my H1. And then recently, I think the EB2 product dates kind of jumped back a lot. They're coming to whatever 2008, late part of 2008. So in your mind, do you see that progressing to 2009 by end of probably September, October, July 2009? What's your initial thoughts on that?
I cannot predict. I'm sorry. Nobody can.
I agree. Okay, no, that's fine. But just want to take your perspective on that.
No, there really is
But,
no predictability in the system. Yeah. Go ahead.
So basically what I was looking was if my new employer would file the AC21, so should they finish the H1 processing and then file for AC21? And
No.
after they file, normally how long would that process take for approval of that AC21?
Look, you're not going to get a separate approval for AC21, and you can file anytime or not at all. It's your choice. I would say file AC21 as quickly as you can. There's no need for you to wait for the H1 visa to come through. And you're not going to get any formal receipt. You're not going to get any formal notification. It just gets put into your file. Okay.
Got it. So only when my priority date becomes current, that's the time they would look at the two job descriptions and compare them if they're same or similar, and then kind of make a decision at that time.
That is correct. Yes, sir.
Got it. And so I have my H1, which is valid until next year. So the new employer is saying after they get my H1 extension for 3 years based on my I-140, they were saying that I don't have to go for a visa sampling, and I could reuse my existing visa to kind of re-enter if I go outside the country. I was not sure how that would work. Any thoughts on that?
Yeah, the same visa is good if you've never been out of status. If you change employers and your H1 is not expired, you can go from employer to employer to employer and still use the same visa. Okay?
Wonderful.
Good luck.
Okay. Thanks a lot, Rajiv. Thanks for your time.
You're welcome. Bye-bye. Okay, let's go on to, there are two more questions, follow-up questions. This is my neighborhood, Virginia. Go ahead, please, Virginia.
Rajiv, this is Sanchi, the question number 11.
11, okay.
Yeah, regarding the layoffs that we're expecting.
Sure.
And I'm here for almost 10 years. So the question is, like if I move to another employer, do I have to move to another employer with the same job profile, or it doesn't matter?
Look, same job profile matters if you are doing AC21. Since you are not going to take advantage of AC21, you don't have a 485 pending, only an I-140 approval. Your job with the new employer can be completely different, and you still can carry the priority date.
Okay, so that allows me to port my I-140 dates as well to the new employer. Is that correct?
That is correct. Now, there is a little problem here, which I have not seen answered. If the company goes out of business, can you still carry your priority date? I think you can. I don't think there's a problem, but kind of get that checked out. Okay.
Okay. Your company itself is not going out of business, but they're making a major change. So we are expecting only one or two departments may be closed. So that's the main expectation at this point, or not expectation, but that's what we are foreseeing at this point. The other question I have is, if I don't find a job within the time period, do I have any additional buffer time? I mean, I'm just trying to see if there is what would the status be if I don't have don't move to another employer within the after layoff, and it may take few more months to get a job. So does it say that that does indicate that I'm out of the status?
Yes, there is no grace period in between H1 jobs. Okay. Now, I have a blog entry. You have to go to our archives and old blog entries and just look for the words laid off, and it tells you how to file a tourist visa to maintain. They're actually moving my blogs right now. We're not done moving the blogs over to the new site, but you'll have the information in the archives. and that's good information. Just look that up. Not the best way to do this, but if you have no choice, then try applying for a tourist visa to maintain status.
Okay. I have one more final question, Rajiv. So if the employer revokes my I-140 after this layoff, does that impact my priority date, or I can still carry forward my priority date?
Your priority date is not impacted, but you then cannot use that I-140 to get H-1 extensions.
Oh, okay. But the priority date is not affected. That's what
It is
I
not.
got from you.
It is not affected. No.
Okay. That sounds a little bit comforting. Thank you very much, Raju. I appreciate that.
You're
Thank you
welcome.
for your time on this.
You're welcome, Sanchi. Good luck, sir.
Thank you.
Okay, last posted question, and then we start with the new ones. North Carolina. Go ahead, please, North Carolina.
Hello.
Yes, ma'am.
Hi, Raju.
Hello.
I'm Tom's wife, and I'm asking a question regarding question number 10. As you talked regarding AVR, right, automatic visa revalidation, so I can use to visit Canada for 10 days, right?
Yes, ma'am.
So my question is, wherever I see that AVR link, it says expired non-immigrant visa. And in my case, my H4 visa is valid till July 2015. So can I use it?
Well, ma'am, the idea of AVR is I came to the US in one status, okay, in your case H4, then I changed to F1.
Right.
I do not have F1 visa stamping. Can I re-enter USA without getting visa stamping? And the answer is yes. Do not surrender your I-94 that came with the change of status. You can use that I-94 to re-enter USA without a visa, without F1 visa.
Okay.
As long as you're
Okay.
maintaining status, going to school, as long as you get your I-20 stamp for international travel, no problem.
Okay.
All right.
Mhm. Okay. And no issues to use air travel mode for AVR, right? If I will go to Canada by air, that is no issue, right?
I do not know of any reason why they
That
should.
is okay.
I can't think of anything that could go wrong with that. No.
I'm sorry?
I cannot think of anything that could go wrong with that, ma'am.
Okay.
All right.
Mm-hmm.
Good luck to you.
Okay. Thank you.
You're welcome. Bye-bye.
Thank you. Thanks for your help.
You're welcome. Okay, folks, anyone has any question, press *5. Any question at all? *5. 1, 2, 3, 4, 5. Okay, 5 people, 6 people, 7 people. All right, 7 people. Okay, guys, I'm counting to 7. That's it. We can't do anything more than that. So if you have something, raise your hand now. Otherwise, hold your peace till the next call. All right, we'll do the 7 questions, 7 people who raised their hands. Starting with, in the order you guys logged in, let's start. I think you are the first person who logged in. New Jersey. New Jersey, go ahead, please.
Hello, Rajiv. This is Shruti from New Jersey. Actually, I'm asking these questions on behalf of my husband. He is right now on open visa in Croydon, New Jersey.
Yes.
The visa was supposed, the open petition was supposed to be valid till April 2015. However, he just got the employment termination notice yesterday, and the job would be valid till 1 more month. That means July 18th. So he was in process of filing EB1 green card, but which hasn't gone through yet through the employer, and now employer is not interested in filing the green card, obviously because of the termination of the employment.
Sure.
So, so my question is, can we file green card, the such petition, and what are the options? I understand that Owen does not have grace period and cannot be transferred to the other employer as well. So how soon green card needs to be filed, and if it is under EB1 category, as long as 485 is current and filed, can he stay legally here?
The answer to your question, how soon? In employment-based cases, even after status expires, if your I-140 485 is filed within 180 days, you are protected by Section 245K as in kite. You can look that up. 245K as in kite. Okay. So
Okay.
you have 180 days after O1 status is gone. But try to do it within the O1 status. And if you file the I-140 485 together, you can stay here.
So the need to be filed till the April 2015, need not to be till the July 2014.
180
Am I
days.
understanding correct?
180 days from the date your O1 status expires.
Okay, and till that time, he can stay in the country, or does he need to leave the country on July 18th, 2014?
He can stay if his I-485 is filed.
Okay.
All right.
Okay. All right. Thank you.
You're welcome. Good luck.
And but one more last question. Is it reasonable? So what are the better chances of getting the green card approval? Is it through the employer based or the self-petition?
The employer based is much easier.
Okay. All right. Thank you.
Good luck, ma'am. Okay. We still have 7 more. Somebody else raised their hand. Okay, guys. This is the very last 7 I'm doing. Okay. Let's go to Washington, D.C. Go ahead, please, Washington, D.C. Washington, D.C., Virginia.
Hello?
Yes, ma'am. Go ahead.
Hello, Rajesh. My question is, my current company is processing my green card, and there is another consulting company who is processing my green card as a future-based employer. So my question is, if my I-140, since my priority date is current, if the consulting company files my I-140 and 485 together, and later my current company's I-140 gets approved, and I want to continue working with my current employer, but I have my EAD from the future-based, that is the consulting company. What can I do in that case?
You can inform USCIS that you want your 485 to be attached to your current I-140. That's no problem.
I-140 from the consulting company?
If you have filed the 485, that 485 can be moved to your current employer, no problem.
Okay. Okay. So, and one more question. Can I get salary hike or any promotions while my green card is under process?
That question I cannot answer. That's something your lawyers have to look at. I think reasonable raises are okay. But somebody has to look at your case. The most important thing is in this is your job description, job title remain pretty much similar, or if not same, substantially similar. So I think pay hike is a question I can't answer in the vacuum. I have to look at the whole case. Your lawyers can guide you with that.
Okay, so is it advisable to get a salary hike? Right?
I don't understand. I don't think you asked me a question. Did you ask me a question about that?
My question was like, so it is not advisable to get a salary hike as well?
I don't know that. I don't think that's a fair statement. I think, like I said, reasonable salary hikes are okay, and also bonuses are okay. So you have to look at. I mean, this is not something I can answer in vacuum. If you ask me, can I double my salary? Probably not a good idea. But reasonable hikes.
No. Yeah.
Okay.
Okay.
Good luck.
Yeah. Okay.
You're
Thank you. Okay. Thank you, Rajesh.
You're welcome. Bye bye. Okay, let's go to Louisiana. Louisiana, go ahead, please. Baton Rouge, Louisiana.
Hello, Mr. Raju.
Hello, sir.
This is Raja from Baton Rouge, Louisiana.
Yes, sir.
Can you hear me?
I can hear you fine.
Okay. My question is regarding the term and I-140 EB2 category. Due to some unexplainable reasons, my EB2 process didn't start until the 6th year of my H1B, which expires on September 15, 2014.
Okay.
As of now, my prevailing wage process is done and the advertising process will be wrapped up on 21st this month.
Okay.
And my attorney said he will be able to file for perm in 1 or 2 days. So he says like it should take 6 to 8 weeks for perm, and there is still time to get I-140 approved. And if required, we can capture vacation on H1B up to this point. I just want to verify if you. One of the things is I want to verify if you see that is a possibility.
I do not. Recapturing is no problem, but estimating perm approval to be that optimistic, like a few weeks, I doubt that.
Okay.
It can happen.
And
it can happen. It can happen, but it's very, very, very unlikely, sir.
Okay. A follow-up question is like, is there any provision considering this kind of situation, like where perm and I-140 can be applied at the same time?
There is no such provision.
Okay.
Sorry.
Then, like, once my perm is applied, even though my I-140 doesn't get through before the expiration, is there an option to still apply for H1B renewal?
No.
Where we may get only for 1 year extension because I-140 is not approved?
No.
Or is that not a possibility because I applied in the 6th year?
Sir, you cannot get an H1 extension until a date from which your labor cert has been pending 1 year. So if you apply in the month of June 2014, you become eligible to kick off a new H1 in June 2015, not before that.
Okay.
If you
I kind of lost in that. Can you just please elaborate a little? Like, my perm
hang on 1
will
second.
be applied in June 2014.
One second. I've got 6. Hang on 1 second, sir. You have to listen also, please. I've got 6 other people waiting. I'm going to do my best, but don't ask me any follow-up questions, okay? I've spent quite a bit of time here. You've got a lawyer. You don't really need for me to go over these basic things, but I'll do it for you just this one time, so listen carefully. There are only 2 ways to get H1 extension beyond 6 years. Only 2 ways. One is based upon your labor cert having been pending 1 year. Okay? So when that provision kicks in, you get H1 extensions 1 year-to-year basis. The other provision is we don't care when the labor cert was filed. If the I-140 is approved, we will give you H1 extension 3-year basis.
Okay.
There is no third way. Okay. So if your labor cert is filed in June 2014, you become eligible only in June 2015 to get the next H1. You are not going to get an H1 extension in 3 months or 5 months or 6 months, unless the I-140 is approved. Then the second provision kicks in. Okay?
Okay.
Good luck to you.
Thank you, Rajiv. This is not a follow-up question, but I just want to see, like, if there is an RFE in EB1 or NIW cases and I want to take a paid consultation from you, do you provide that?
We do. I don't recommend that you put money into that. Look, I charge $880 an hour. Typically, 15-minute consultation is $220. I don't think I'm going to be able to do much for you. What you can do is run your resume by me before you file the application. I don't charge for resume reviews. Okay? Good luck.
Thank you very much. Thank you for your time.
You're welcome. See, the problem is once you've already filed an NIW and EB1 and you got an RFE, there's not much I can do for you. We can make some suggestions, but if your resume is strong enough and then you get an RFE, then maybe somebody like us can help you further explore your options for response. But if the resume was not what the government wants to see to begin with, why waste money on second opinions? Pennsylvania. Go ahead, please, Pennsylvania.
Yes. Hi, Rajiv. My name is Chirag, and currently I'm on a TD visa in Pennsylvania.
Yes, sir.
And my first question is like, can I convert my TD to E2 visa if I invest 100,000 in Pennsylvania?
I would not answer that question in that format, but I will answer it in two different portions. First question, can TD convert to E2? Yes.
Yes.
Is $100,000 enough for an E2? I don't know. It depends upon the case.
Okay. It is like $150,000 sub franchisee that I want to put it in 100,000.
Difficult to say. Theoretically possible. Is it highly likely? No. See, when the amounts are relatively small, what the government wants to see is that you are paying a large amount of the cost of the acquisition. Let me explain to you what I mean. First of all, consulates have been eternally confused about the valuation of the business and the cost of acquisition. You know what the difference between the two? Let's say I buy a gas station and the gas station is worth $3 million. But in order to buy it, I have to only invest 1 million and the other is a loan on the property. Okay, that means the cost of acquisition is only $1 million. Okay, now government says when you invest, they want you to invest a large part of the cost of acquisition. And the smaller the money you're investing, the larger the percentage of the cost of acquisition you must put down. Okay, so generically speaking, you can do this. And E2 is one of those very problematic visas for smaller investors where Canadian government, Canadian consulates, US consulates in Canada have not been consistent in understanding the difference between cost of acquisition and the pricing or the valuation of the business. So all in all, theoretically speaking, I would say an E2 is possible. As to what the strength of the case is, I cannot comment. Okay.
Okay. So like according to your advice for 150,000, how much investment should I show to stronger my case?
Well, I don't think there's a number I can give you. There is actually no particular numbers fixed. I know people, in fact, there are cases in the books where people got E2 visas with just $50,000 investment a few years ago. Okay, those consulting businesses and people were able to invest very little amount of money and still acquire the business. So it depends upon the case. It really is not a number I can give you. The most you can invest, the better off you are. And I would also advise you, don't put the money down into the business. Put it in an escrow account with a condition that the money will be released from escrow if the E2 visa gets approved. That way, if the E2 does not get approved, the money comes back to you.
Okay.
Okay.
And if suppose like that particular my sister's corporation, that particular subway is for, and if I invest into that corporation, if I get my E2 visa, then would there be any problem with that?
You'll have to get yourself a lawyer and look at the whole case. I can't really comment here. Okay, so this is generally speaking, E2 visas require substantial investment. Substantial is not defined. They require that the investment must be such that it's not something you're just making a living through. It is something which is actually bringing you more than just a living. Okay, so it shouldn't be marginal in other words. So there are these 3-4 things that they look for. Then they want to see what kind of control you have on the business. These are the things that they would look for, but I can't really give you a template for a successful E2 visa. Get yourself a lawyer. It is definitely worth looking into. Let them take a look at the transaction. Let them take a look at the valuation of the business, the cost of acquisition, and then decide for you. Okay?
Okay. So, like one more question I have that because I'm a Canadian citizen and right now I'm in Pennsylvania on TD visa. So, should I go back to Canada to get E2 approval,
you can do a change of status within USA, but if you ever travel outside USA, you will have to go to the consulate. E2 and K visas are the only exception to the general rule that Canadian citizens don't need a visa. If you go outside, you don't need to go for an E2 stamping. Okay?
Okay, so I don't, if I travel to India, let's say, and if I come back, I won't get in problem.
You will need a visa, sir. You will need a E2 visa.
Okay.
You'll have to go to the consulate for E2 stamping.
Okay.
Okay?
So after I get approved, after I get a change of status over
Okay,
here.
I'm going to have to cut us
go
short.
to the-
Sir, I've got 5 more people waiting. Let me just give you the bottom
Okay.
line. The bottom line is I would like guys to please be considerate for everybody else. Let's just try to make the questions short. We don't have time for a very
Okay.
lengthy discussion. Let me just put it to you this way. You can do a TD to E2 conversion within the United States. But if you travel outside USA, you have to go to the consulate. As long as you stay in USA, you don't have to go anywhere.
Thank you.
Okay? Good luck.
Okay, thank you for your time.
You're welcome, sir.
Okay, thanks.
All right. Let's go to New Jersey. Thank you, guys. Thanks for your patience. I'm doing my best to run through as many questions as I can. New Jersey, go ahead.
Hi, Rajiv. My name is Tanmay, and I have the questions for EB2 category qualification.
Okay.
So I have the 3 years bachelor's in chemistry
Okay.
from India. Then after I have completed my MBA from India for 2 years, and then I came on the student visa here and completed my master's here. So currently I'm working for JP Morgan Chase as full-time employee on H1B.
Okay.
So like what kind of requirement? Means I have total 4 years of experience. So what kind of requirement make me eligible for the EB2 category?
What is your master's degree in, Tanmay?
My master's in technology management.
Okay. And are you working in technology
And I
management?
also have the,
Are you working in technology management?
yeah, I'm
Okay. Well, you
yeah, currently actually I'm working in the market.
is your degree from an accredited school in USA?
Yeah, I graduated from the University of Bridgeport, Connecticut.
Okay. You already qualify for EB2 because you have a US master's degree.
Okay.
You don't need experience
So
to you don't need experience to
Okay.
qualify for EB2. Having a master's by itself meets the requirements.
So my 3 years bachelor's degree plus 2 years MBA from it, it doesn't have any issue, right? Because
has-
I only have the 3 years bachelor's, not the 4 years.
No issue at all because you have a master's degree from an accredited school in the United States. No problem at all.
But they have to mention in the requirement, right? In that means masters required, right?
I'm not, yes,
The master's
yes,
preferred.
yes. The degree has to be required. You cannot just say preferred. Degree has to be required. Get a job that requires that degree.
So bachelor's. Okay, so bachelor's plus 5 years or master's plus 2 years, kind of that kind of requirement will fit, right, for my EB2.
It probably will not work. Let your lawyers tell you what will not work. I'm not going to draft a perm application for you here, but you qualify for EB2. Rest is up to the employer's lawyers. Okay.
Oh, okay. And can I show my unpaid OPT experience for my green card process?
You can, yes.
Oh, I can. Okay. Yeah, that's what I have.
Good luck.
Thank
to
you. Thanks, Rajeev.
You're welcome.
Thanks.
Mhm. Okay, we have 3 more questions, 3 more individuals. Let's go to California. California, go ahead, please.
Rajiv, this is Akshay, and my question is regarding a perm petition that has been filed by my employer. In the perm petition, there is a section for the job opportunity requirement, and they have mentioned that the requirement is an MBA in marketing or strategy. And my transcript or degree only says I have an MBA. It does not say my major in the MBA program. Is that going to be a problem?
No, Akshay. What you can do is, it's kind of funny. I just finished a case like that where we did not have, we have a degree in environmental resources, but this lady has a lot of coursework in GIS. So I've talked with a evaluation service, and they are willing to put down that she's got a master's degree in environmental resources with a minor in GIS. So you can actually approach your school. They might be able to give you a letter like that, or you can get something like that from an evaluation service that might be acceptable to the government. I think it'll be okay.
All right, that is helpful. I'll check with my school or an evaluation service.
Right.
Second is the job title mentioned in the alien work experience section. They have mentioned my current job title with my current employer as marketing specialist, whereas my actual job title in the company is director of account management. I'm not sure what are the legal implications and how those things are decided.
I don't like.
Is that going to be another?
Yeah, I don't like the way that sounds. That does not look to me like a similar situation. I don't think this PERM application is sounding up and up to me. Because if you're working at a director level and then you have a labor cert filed for a much lower position, I don't know what's going on. I mean, technically, yeah, it can be done, but I don't know. It does not, that part I don't like, actually. I don't like it. Okay. So
you don't recommend doing.
I don't like why they did that. I don't like the fact that they did that. What is the reasoning behind it? But then I don't have the information that your lawyers would have. So I don't know what the reason for that decision is. But just the facts that you described to me don't look good to me.
Yeah, that is making me concerned as well. Actually, the salary offered for the PERM job offer is much less than the actual salary that I make in my current role.
It's a very bad idea. I don't know what they're thinking, but that's not a good idea. I don't know what they're thinking. You may want to have a second opinion on this case, and you may need to start another green card application.
Okay, all right. And they have also made an error in one of the job titles that was mentioned in the PERM petition from my last employer.
What is
I questioned them, but they have given me.
What is the error?
So my job title with my last employer was vertical analytics manager, whereas in the PERM petition that they filed, they said the title is manager business strategic analyst. They claim they are related or justifiable, but there is a difference. I mean, straightforward difference between the job titles.
But
the manager part is same, but vertical analytics was the actual title. Business strategic analyst is what has been mentioned in the PERM petition.
Is the job description accurate
though? When you say job description accurate, the accuracy will be confirmed with the experience letter that I get from my past employer, right?
Experience letters should be accurate. They should not be made up. Okay.
Yes, I mean, whatever experience letter I get from the employer.
Yeah.
And usually the experience letter that I would get will be based on whatever was mentioned in the offer letter, nothing apart from that.
Okay.
So, in fact,
I think you need a second opinion. I am not comfortable with the way this is handled. I'm not that concerned about minor variations in titles as long as the job descriptions are accurate. But I am concerned about them filing for a much lower position. That makes no sense to me. Okay?
Okay.
Good
luck. All right.
Good luck.
That's helpful.
Yes, sir.
Thank you.
You're welcome. Okay. We've got two more, last two. Let's go to Michigan. Michigan, go ahead, please. Michigan.
Hello. Hi, Rajiv. Can you hear me?
I can hear you. Yes, sir.
All right. I had a question regarding extended stay in India. So my wife is and me are currently in India, and she has been employed by this company since October of 2012 on an H-1B visa. We came here on 31st of March because of some family compulsions, and she's planning to actually stay here till 21st of September. So that's like a close to 6 month stay. So her company has a flexible work arrangement in their policy, and she's working from home from here. She's not getting any salary paid in India. It's only in the US that she's getting paid. So I wanted to know if there is any kind of a limit for such a stay outside of the US, and if she will face any problem during immigration.
You said you have green card right now, right?
No, H-1B visa.
H-1B visa. Well, the good news is there is no requirement that an H-1B holder must stay in the US all through their H-1. In fact, regulations provide that if in any 12-month period you are in USA for less than 6 months, you get the whole year back. So the regulations actually allow you very clearly to stay outside USA and come when you need to. There's no problem at all.
Okay.
Okay, there's no limit.
All right.
No limit.
And so she will definitely have some documents from her office when she plans to come back to the US on the 21st. So hopefully immigration should not be an issue. And also, is there any kind of a taxation issue that might arise due to this?
Oh, you don't want me to give you tax advice, sir. I am very poor in tax law. So talk with a CPA. I know that India and USA have double taxation relief treaties. You may want to talk to a CPA or a CA on this issue. I don't know how taxes work.
Okay.
All right.
And just one more part from this. Her extension is up for renewal next year. So I believe in the extension form, we need to mention all our in-out dates as per our I-94s and stuff. So this would show up like a 6 months period in between. So again, any risk there having a 6 month stay? It's basically because she would then cut it down to like 3 months or something. So
oh, no, I don't see any problem at all.
Okay. All right. And just another quick add-on question with my H-1B visa. I'm throwing the lottery, but still waiting for my petition to go through. So is it right that I can enter 10 days before October 1st on an H-1B visa?
That is correct.
Okay. So, I mean, that's why we are planning to come together, travel together on the 21st on her H-1 and my new H-1, hoping everything goes well. So,
good luck.
Okay. All right. Thank you, Rajiv. Thanks for your time.
Take care. Bye-bye. Last question of the day, folks. Kansas. Go ahead, Kansas, please.
Yeah. Hi, Rajiv. First of all, I just wanted to appreciate all your efforts that I received, like when my case was with your team. So, and I had a follow-up question on my case. So before coming to US, I had a managerial position in India, and I was working for more than a year with them. And then due to the nature of the position, when I came to US, I came on L1B specialty occupation because the position required a specialty knowledge.
Okay.
And then recently I moved to another employer on H1. But now I came to know that my previous employer is also applying for the green card. So can I go back to them and ask them to apply in EB1 for me?
We'll have to look at the time frames. When did you enter USA?
This time I entered in January 2014 only, but on L1B I entered on 2010.
2010. No, I think it's too late. When did you change employers?
I just changed recently, like just 2 months back.
You know, it might be possible because if you are working for that same company on an L1B, you have to be employed in a managerial capacity 1 year out of the last 3. And the last 3 gets counted back from 2010. And I think it might be possible. Worth a shot.
Yeah, I mean, Rajiv, I was with that company for 11 years. So it's like from from 2003 onwards to 2014, I was with them, and I just moved on to another employer on an H1.
I think it's worth a shot. You know what you can do? Here is an easy way to do this. File an L1A premium processing. Okay?
Okay.
If the L1A gets approved, that means it is quite certain that you will get an EB1 also.
Okay, yeah, so basically when I move back to my employer, I should ask them to do a change of status from H1 to L1A, and so that the EB1 is possible, right?
Exactly, and do it premium processing. Within a couple of weeks, you know what your EB1 stand is going to be.
Sure.
Okay.
Yeah, I think I will try. And then there is one more question, Rajesh, if you allow me to ask that.
Sure, go ahead.
You just mentioned for a last question that if somebody is staying out of country for more than 6 months, then they actually get a 1 year back. Yes. Instead of, so is it like if my employer allows me to stay out and work from India for 6 months, then when I come back, can I actually recapture instead of 6 months, a year full?
Over 6 months. If you are outside USA for more than 6 months, in any 12-month period on H or L, you can get the entire 12 months back.
Okay, so if my employer and my client are okay working with me from India, then when I come back from 6 months, after 6 months, I should be able to recapture a year, right?
More than 6 months, yes.
Okay, yeah, more than 6 months. I understand that.
Right. Yes, you should be able to recapture the whole year.
Sure. Thank you, Rajesh. And once again, I just want to say that I really get a very good support and help from you and as well as your whole team during my H1 case. So, yes.
Absolutely our pleasure. We love what we do and we like working with all of you guys. So thank you. Take care, sir.
Sure. Yeah. Right. Yeah. Thank you. Thank you.
You're welcome. Guys, thank you very much for being here. I always enjoy talking to all of you. In 2 weeks, we will talk again, and I appreciate your patience waiting so long to have your questions answered. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.